And I welcome you all to the Law Council of Australia 2023 referendum webinar on the role and value of a constitutionally enshrined voice. I acknowledge that I am hosting this webinar from the lands of the Turrbal and Yagara peoples, who are the custodians of mirage, Brisbane. I would also like to acknowledge the Aboriginal and Torres Strait Islander custodians of country of the various lands on which you all live and work today, and recognise their continuing connection to land, sea, culture and community. I pay my respect to elders past and present, and extend my respect to Aboriginal and Torres Strait Islander peoples participating in this webinar. My name is Luke Murphy, and I am the President of the Law Council of Australia for 2023. It has been a great privilege to me personally to be President in the lead-up to the 2023 referendum. It has not been easy, particularly in the age of digital and social media, to promote a focused, robust public dialogue. However, I have been buoyed by the numbers of our profession who have contributed willingly to this task. I also recognise the remarkable resilience of our First Nations colleagues and friends during this difficult period of robust debate. The Law Council has a position in support of amending the Constitution to provide for an Aboriginal and Torres Strait Islander voice to the Parliament and the executive government of the Commonwealth. This is what all Australians are being asked to vote on in October. The Law Council has supported a constitutionally enshrined voice, as articulated in the Uluru Statement from the Heart, since 2017. As a national peak body, part of the Law Council's work is to analyse and provide advice on the legislative proposals of Parliament and the policy initiatives of the Australian Government. The Law Council is therefore well placed to observe a legal policy landscape in which Aboriginal and Torres Strait Islander peoples are disproportionately and detrimentally impacted by the powers of the Parliament and executive government, the laws and programs made about them, but without their proper input. A landscape in which Aboriginal and Torres Strait Islander peoples commonly have the information and solutions about what will work most effectively for their communities. However, they need a voice equal to their aspirations, knowledge, and lived experience. The Law Council has long considered a constitutionally enshrined voice as critical to addressing the social and political disempowerment of Aboriginal and Torres Strait Islander peoples. It has called consistently for a referendum to accept the powerful and peaceful invitation issued in the Uluru Statement for all Australians to move together towards a better future. The Law Council has long supported the principle of a voice, and the Law Council supports the proposed amendment to the Constitution. In consultation with its Voice Referendum Working Group, its Indigenous Legal Issues Committee, and our constituent bodies, the Law Council has considered the proposed constitutional amendment, the referendum question, and the referendum process more generally over the past year or so. The Law Council's view is that the constitutional amendment as proposed is constitutionally orthodox, is just, and is legally sound. Today is an opportunity to explain this position in further detail I extend my thanks to the 4 distinguished panellists joining us for today's webinar, all of whom have contributed on our Voice Referendum Working Group. Our panellists are Professor Dr. Megan Davis, who is a Cobble woman of the Burrunakam Nation. She is the Pro-Vice-Chancellor Society of the University of New South Wales, Sydney, and the Balnaves Chair of Constitutional Law, a Professor of Law and Director of the Indigenous Law Centre at that university. The Honourable Kenneth Hayne AC KC, who served as a former Justice of the High Court of Australia for 18 years, from 1997 to his retirement in 2015. Kenneth then led the Royal Commission into the misconduct in the banking, superannuation and financial services industry in 2017, and is a professorial fellow at Melbourne Law School. Professor Cheryl Saunders AO is an expert scholar in Australian and comparative public law and constitutional law. She is the founding director of the Centre for Comparative Constitutional Studies at Melbourne Law School, a President Emeritus of the International Association of Constitutional Law, and a Senior Technical Advisor to the Constitution Building Program of the International Institute for Democracy and Electoral Assistance. And Mr Greg McIntyre SC, who is President-elect of the Law Council, and who is a barrister who throughout his career practiced with the Aboriginal legal services in Western Australia and Queensland, before being appointed as Senior Counsel in 2002. Greg has conducted the High Court cases of Kawata and Bielka-Peterson, Mabo in Queensland, and Rofi and Western Australia. Megan, Kenneth and Cheryl have also been closely involved in providing legal guidance on the content and drafting of the constitutional amendment as members of the Constitutional Expert Group chaired by the Attorney-General. Professor Dr. Megan Davis was also a member of the First Nations Referendum Working Group, advising the government on the referendum and, of course, what is one of the architects of the Uluru Statement from the Heart. Can I thank those of you who have submitted questions for our panellists ahead of today's webinar. We will do our best to cover the issues you have raised in the time available. We trust this discussion will be valuable to you all, in particular in your roles as lawyers and community leaders throughout Australia, and in ensuring the whole Australian community better understand the legal need and the basis for the referendum question. If I can firstly direct the first question to Cheryl, and sorry, I should say that Professor Dr. Davis has been delayed in joining us, but she will join us very shortly. Cheryl, one of the questions submitted for us today suggests that people are resistant to changing the Constitution. And in some circles, the Constitution is sacrosanct. Should we be wary of constitutional change? And what is the fundamental role and purpose of the Constitution?
Thanks, Luke. Well, the Constitution provides the framework for our system of government, and it's deliberately protected by a special alteration procedure, which involves the referendum, which we're heading to in October. But it's not supposed to be entirely resistant to change. I have done some work on what the framers had in their minds when they chose the mechanism in section 128. And they deliberately chose that mechanism, thinking it would make our Constitution a bit more flexible than the American one, which they were otherwise following in some respects. And certainly they understood that the Constitution they were leaving us was not perfect and would need to be changed in various respects. So yes, we've got to be cautious about to ready change, but that's hardly our problem in this country. Just means that we need to look at proposals for change and understand them and make up our minds in a sensible way.
The important thing, Cheryl, there is, isn't it, that the drafters and formers of the Constitution actually, as you've said, saw the need to change and facilitated that. The process required for change, though, was motivated by different issues, the need for the double majority, for example.
Oh, sure. They knew that there would need to be a federalism dimension in the constitution alteration process because they were putting a federal constitution in place. But they thought they had come up with a formula that was useful for the Australian context. They actually adopted the double majority requirement from Switzerland, which had a reputation of amending their constitution from time to time.
Thank you, Cheryl. Greg, if our constitution belongs to all Australians, is it problematic to enshrine in it a voice for only one group of Australians?
Is a mechanism for recognising the First Peoples of Australia, and it's a tangible way of giving that form of recognition. So that's what is the thought behind it taking that form. The second thing is that what the constitutional amendment will do will give the voice the power to make representations. The power to make representations is something which all Australians have. The Law Council for Australia, for example, describes itself as the voice of the legal profession, and the Law Council makes representations to the Parliament and to the Executive on a regular basis, if not daily. Various other interest groups are all capable of making representations to the Parliament and to the Executive. So in that sense, it's no different from the rights that all Australians have. The third thing is that within our Constitution, it's not the case that the Constitution doesn't provide specific rights for different groups of people. For example, in Section 51, there are powers to make laws for invalid, aged and widow pensions, for the unemployed, for married people, and in fact to decide who in fact are married people. And there are powers to make laws about... There's power to make laws about aliens, about migrants, and power to make laws about people of any race, and for the territories which affect Territorians. And we've seen examples of that where the Parliament chose to make a law in relation to the Aboriginal and Torres Strait Islander Heritage Protection Act, which specifically excluded the Hindmarsh Bridge development from the operation of that piece of legislation. And the High Court dealt with that in the Cartanieri case, so that the Commonwealth made special laws which were unfavourable, if you like, to protection of Aboriginal heritage. They similarly, in relation to Territorians, made special laws which enabled the Northern Territory intervention into the intervention by the Commonwealth into the Northern Territory, and dealt with a whole range of issues related to Aboriginal people in the Northern Territory. And they also made special laws to prevent the Northern Territory, the ACT and Norfolk Island from making euthanasia laws for a period of time. So it's not the case the Constitution does not deal with groups in different ways.
Great. Ken, Megan, welcome and thank you very much for joining us. Ken, did you wish to add anything to Cheryl or Greg's comments?
No. They were both excellent answers.
You. Megan, if I can direct a question to you, in relation to the origins of the voice, it's in the public discussion in recent months, one of the common comments has been that the process is being rushed, that more consultation is needed, and that constitutional recognition should have stopped short of a representative body. Would you please take the time to address the origins of the voice proposal, where it has come from, and is it supported by Aboriginal and Torres Strait Islander people?
Yeah, thanks, Luke. I have heard that argument bandied about over the past couple of months, which I think is a consequence of the opposition leader saying he will run a second referendum just on recognition. But this country's been doing or formally involved in a recognition process now for 12 years. There's been 8 different processes and 11 different reports in 12 years, all on constitutional recognition, which with the primary purpose of those mechanisms to get us to a referendum. But the overarching question was, you know, what form of recognition? So it's never been the case in Australia or in this discussion for 12 years that recognition just means the dictionary meaning of acknowledgement, which is why we have been confounded and find it inexplicable that the opposition is now saying recognition only means acknowledgement and that voice is a different thing. When in fact in this 12-year process, by about the 5th or 4th year, it was apparent that the non-discrimination clause that the expert panel had put up would not be acceptable to the opposition or to the Labor government as a form of recognition. So part of the Referendum Council's work was to go back out to Aboriginal communities and ask them, well, what is meaningful recognition? The answer to that was, as most people can see from the Referendum Council report, a rejection of symbolism. That's not dissimilar to what research shows Australians, the Australian population sentiment as well. During the expert panel, Australians said there's no use having symbolic recognition if it's not going to change anyone's lives. Otherwise, it's regarded as tokenistic, and that was the language that came up in that research in 2011, 2012. But the Referendum Council process showed First Nations peoples rejected symbolism as a form of recognition on its own, and that they would not support something that wasn't substantive and wouldn't make a change to people's lives. So I just wanted to make that first comment because I find it interesting that people are trying to argue that voice is not recognition, when in fact the whole process over 12 years has elicited a response which is recognition through a voice. But I'll go back to your kind of first question or last question. I just wanted to say, yes, this is supported by Aboriginal and Torres Strait Islander peoples. So we've done 2 major pieces of research which show 83%, 82% in 2 different polls, Ipsos and YouGov being the highest sample, which was 700 people, I believe. But the Reconciliation Barometer also did a survey and has done regular surveys that show over, I think they've got 87, 88%. We're confident that our people support this. And we say that also because when we ran the Uluru Dialogues, the sample was a robust sample of traditional owners and elders from communities across Australia. And so I think all that's happened in the kind of campaign proper is that mainstream media has elevated the no voices to the same level as yes. And that's effectively what's happened, in that Australians are getting the impression that there is a massive kind of groundswell of not support for this from Aboriginal people. And my comments are based on research and data. We know our people support it. So in terms of the kind of main question, where has this come from and is it rushed? You know, it's been the product, as I've said, of many, many years of work. The very first process, as I said, was in 2011, which was set up by Julia Gillard, and we've had multiple processes since then. The voice proposal really developed, I mean, the notion of a voice has been around since the early 1800s, right? The idea that Aboriginal people need a more enhanced role in the decision-making of the democratic state. Certainly in the early colonial periods, a number of our elders felt that our views weren't getting heard as the laws and policies that dispossessed their lands and led to protection were being implemented. Those colonial parliaments were not taking into account Indigenous views. So there's a very early tradition of our people wanting a say or an active role in what our democracy does in terms of our issues. And so in the post-Federation framework, we've had 6 or 7 mechanisms that have been set up that have been representative mechanisms, because the federal government over time has found that they need Indigenous input if they're able to make, you know, quality laws and policies that actually have an impact on communities. So it's quite an old reform, but it became more of a primary reform in the post-expert panel period, simply because the kind of non-discrimination clause, or what Tony Abbott called a one-clause Bill of Rights, didn't get the political support that would be required to get it to a referendum. And as everybody knows on this call, you can't do anything in this country without political agreement. Political agreement is really critical to the momentum of that recognition phase, and non-discrimination was just not going to get bipartisan support. So a big part of that work, led by Noel, and then also led by the Indigenous Law Centre, was go back to the drawing board and think about, well, what might be a constitutional mechanism that doesn't require the input of the High Court, you know, in the way that a non-discrimination clause would? What might be something that's a political mechanism that would at least allow our people to have a say in laws and policies? And that's what the Voice is. A huge amount of work has been done on it over 7 years. It was the consensus decision of the Uluru Dialogues, which was the first constitutional process that's ever been set up in this country to include Indigenous peoples in constitution, in the Constitution, and we all know that Aboriginal and Torres Strait Islander people have been excluded from the constitutional order, or were at the very beginning. It was a ground-up process that we ran. They endorsed the Voice as being the kind of reform that, although there's no obligation on the state to respond, would actually make a big difference to our voices being heard through the issuing of constitutional representations. So I'll wrap it up, Luke, because I think that your last question about is constitutional recognition enough on its own, the answer is no, simply because there's no evidence or research anywhere in the world that a simple statement of fact can elicit the kinds of transformative changes our communities need to thrive. And that is why people don't support symbolic or acknowledgement alone. Luke, I should say that when you look at recognition in processes like these, recognition sits on a spectrum where one end is a weak form of recognition and the other end is a strong form of recognition. And what that means is weak means mechanisms that the state, that cannot compel the state to do anything, it can't prohibit the state to do anything, and it doesn't empower Indigenous people either. And at the other end of the spectrum is strong form recognition, and that exists in countries like Canada with a kind of Section 35 that we will never see in our country. But the question has been for 12 years, Luke, where do you sit on that spectrum? And the answer from 12 years of this work, including parliamentarians, including the LNP, has been that it doesn't sit at the weak end. It sits more up towards strong, although it's not the strongest form of recognition. And so that's my answer to that question about constitutional recognition. The last being, lawyers ruled it out in 2014, 2015, 2011. This was ruled out a long time ago as a lone reform because it is very legally risky and technically, constitutionally legally risky to just introduce a statement into the Constitution It is very complex, and I'm surprised that the complexity and the legal risk inherent in this preamble that Dutton is talking about hasn't been raised, given the arguments that the voice is legally risky. Well, I think he's put on the table something much more risky.
Thank you for that, Hayne. I'll come back. I'll get you just to expand on one further aspect of that. But did any of the other panelists wish to add anything to Megan's answer there?
Can I just say very briefly, Luke, that I completely agree with that last point that Megan made. I think that a merely symbolic statement in the Constitution would freak people out, because we have a Constitution where every section has some work to do. The proposed section 129 would have some quite restrained work to do. And a mere symbolic statement would make people think, my God, what's the High Court going to do with that? So I've always thought it was a complete mirage to be on the track. And I think people need to think about what that would actually look like in practice.
The likelihood is that the High Court would do nothing with it, because it would be incapable of having any mechanism or action following from it. So in that sense, it's a rather worthless concept.
No, we would have a huge brawl over whether to add a section saying it's non-justiciable. That's where it would take us, and that would be just really pathetic.
Which kind of occurred during the Gillard process, right? And when we did all of that kind of consultation with the Australian community, they felt a non-justiciable clause added to a statement of recognition was offensive.
I agree.
Hayne, could I just get you to expand on one aspect of the history and the work that has been done? Because it's something that I've thought is been misrepresented in some of the public dialogue. And that is just some of the fundamental details around the Uluru Dialogue, the work that went into the consultation nationwide, and the structure around it, because I think it is important that the profession has a clear understanding that there has been no consultation of the nature or extent that was undertaken in that process previously.
Yeah, sure. And I should acknowledge Cheryl was a really important part of this, because a lot of the dialogue design was built off the Centenary of Federation work that had been done, where mini dialogues had been run with the public in primary schools, local councils. And there was a lot of information from an extraordinarily huge report that Cheryl kindly sent to me, where there was a lot of data about what worked and doesn't work in a country like ours when you're going out to talk about the Constitution, and civics education isn't very well taught or known. So a lot of the fundamentals of those dialogues were built on an evidence base that had already been taken place for the Centenary of Federation. And I should say Melbourne Law School also hosted our trial dialogue, where we brought all of the blackfellas from right across the country in to run a trial dialogue and build our methodology off the back of a trial. So we were asked, I guess, in 2015 to join a referendum council. The idea at that point was that the expert panel recommendations had run out of steam, and also Aboriginal and Torres Strait Islander people hadn't been properly consulted, which meant we were kind of retrofitting, consultation with First Nations people quite a long way down the track when it should have been done at the very start. And so we had to make a decision about how to do that. It was the first constitutional consultations of their kind in Australia's history. And how do you do that across a nation like ours with so many First Nations entities? So we created a subcommittee, and we set about designing what we think would be a fair process with a really robust sample of our communities, because of course no process can ever consult every First Nations community, but we wanted a very large spread of First Nations. Because we are a gerontocracy, our decision makers are our elders and our traditional owners, so our old people. And so we wanted to make sure that they were prominently represented their groups in the dialogues. So we originally were going to run 35 to 32 based on the Australian Electoral Commission's breakup of the nation that they used for ACSIC elections. The AEC had worked really closely with traditional owners in doing that AEC map and tried to get each 35 electorate across the Federation as closely fitted to regional groupings of particular First Nations peoples so that they could try and retain some sort of cultural thread, knowing though the way that the federations or the states and territories are often cut through First Nations territories. So we didn't get the money to run 35. The money was reduced to what we ran, which was 12. So we needed to make sure each of the 12 dialogues were run really well and in a really robust fashion so that when the result came out at the end of the day, Australians would know that it came from a really robust basis, our decision makers, the people who decide things in our culture. So we ran them over 2016 and 2017. In 2016, we actually spent the year designing and we ran the trial dialogues towards the end of the year. What we had to do first, as is normal in our culture, is we had to go out and travel the country and get input from mob as to what the dialogue looked like. And so Cheryl and I had done a lot of work on that. And so we did that as well as we ran 3 major meetings across 2016 with traditional owners and Broome, with First Nations peak bodies, so in the health sector, education sector, justice sector, etc., on Thursday Island, and then a major meeting in Melbourne of significant Aboriginal leaders in the struggle. They all gave input into the dialogue. We'd run through the whole dialogue, what we were going to show, the civics education, the legal education, the options, all of it we ran through and got feedback, critical feedback, helpful feedback, put it all into a method and a design, trialled it with Cheryl's mob at Melbourne Law School, and then started the dialogues in Hobart in December, keeping in mind at that point cyclone season was kicking in, ceremony was kicking in, and there's all sorts of reasons why you can't go out and just run consultations with mob across that period. So we ran them up until May 2017. Every single dialogue was run exactly the same way. It was entirely Indigenous peoples in the room, except for 4 constitutional lawyers, including Gabriel Appleby, Sean Brennan, Dylan Leno, who were in the room to ask questions when I couldn't ask them. I was too busy running around helping with Annie Pat, so they were amazing in the work that they did. Each breakout group was devoted to an option that Malcolm Turnbull and Bill Shorten had signed off on. And each of the working group leaders who led the process were flown into Melbourne Law School to participate in that trial dialogue. And a lot of work went on with them from the end of 2016 into 2017, so they knew fully how to manage the discussions, which were semi-scripted in each of the working groups about the models that Turnbull, that the LNP and Labor had agreed for us to take out. So the numbers were capped at 100 in every dialogue. And that was really important because we needed to have the right resources for the people who participated. There were some who thought we should just have town halls where anyone could rock up. And I think someone in the government suggested a clicker type decision process. So you come in, hear a presentation, then people click, and the top clicked model would become the reform that goes forward. But it was the most comprehensive and significant consultation ever done with First Nations peoples on the Constitution. It was a really ground up process. It was underpinned by cultural authority, including the many numbers of traditional owners and our elders who participated in the dialogues. So, I mean, I'm not sure how much more to add, Luke, or whether you have any questions about it.
That's Very comprehensive, thank you. And I thought it was of the utmost importance that the profession understands, as you've just conveyed, the depth of the consultation and the coverage and the thought that went into the whole process. So thank you very much for that. If I could just move to another question that one of the attendees has asked, and that is that the proposed constitutional amendment, section 129, it has introductory wording and then 3 subsections. Kenneth, can I ask you, what was your view when reading and analysing the proposed amendment of how it has been drafted? Do you consider the drafting to be sound?
Thanks, Luke. Let me begin at the end. Do I think the drafting sound? Answer, yes. An unequivocal, unqualified yes. The wording which is on the screen for all of the participants in the webinar to look at is very simple. It says what it means. It means what it says. That's its great strength. Although it's been said repeatedly, I do invite the audience to look at what it says. It begins with, in recognition of Aboriginal and Torres Strait Islander peoples as the first peoples of Australia. 1, there shall be a body to be called the Voice. 2, the Voice may make representations to the Parliament and the Executive on matters relating to Aboriginal and Torres Strait Islander peoples. And 3, the Parliament shall have power to make laws with respect to matters relating to the Voice, including composition, functions, powers and procedures. Now, that drafting is wholly consistent with the balance of the Constitution. As Cheryl said, the Constitution sets out framework. It sets out principle. The Constitution is not where you put the mechanics of operation of the bodies that are dealt with in it. Rather, as proposed 129.3 says, those are matters for Parliament. Parliament has the power to make laws with respect to matters relating to the Voice, including composition, functions, powers and procedures. So the drafting is simple, it is sound, it needs to be read and understood.
Thank you, Ken. Cheryl, in your view, the proposed amendment, will it fundamentally alter our structure and our system of democratic government, given its simplicity that Kenneth has just explained?
Not at all, Luke. In fact, I think it fits with it extraordinarily well. Megan, a little while ago, described the range of options that was on the table before the dialogue process began, culminating in the Uluru Convention. And none of those options really struck you as being right. And when the Uluru Convention came out with the idea of the Voice, I remember thinking, God, that absolutely fits. Why didn't I think of that earlier? Because ours is a system of government that relies very heavily on institutions, relies very heavily on our federal democracy. That means that our elected representatives need to be responsive to the views and wishes and preferences of the people. And what the Voice does is provide a mechanism, a transparent public mechanism for that to happen in relation to First Nations peoples in this country. It leaves the final decisions of the government and Parliament, but it provides a mechanism to strengthen the way the democratic process works. So it's a very Australian solution, I think, to the challenge of representation of peoples.
Very much, Cheryl. If I can move on to another issue that has been raised in the public discourse, and that is that the proposed change to the Constitution enables the voice to make representations to both Parliament and the executive government. Megan, are you able to explain the reasoning behind including both the Parliament and executive government? And is it appropriate that the voice speaks to executive government? That has been an issue that has been the topic of much discussion so far in the discourse.
So, I mean, it was always envisaged that the voice would be subject, the Parliament and the executive, the voice could speak to both. I mean, we say it's not just appropriate, that it's absolutely essential, because the business of governing is done at the executive level. And that's done by the public service, who is one of the most unaccountable groups in the government system, with the most power over the lives of First Nations peoples day to day. And I know that's very hard for Australians to understand, because, Reconciliation Australia polling last year showed that, less than 85% of Australians have never met an Aboriginal person before. And so it is difficult for many Aussies to grapple with this idea that bureaucrats subjugate a community in this way. But once the referendum working group, was working on the amendment, it was unanimous that the advice, it was unanimous endorsement of what the Uluru Dialogues had done, that it has to apply to the executive level. And it's always been the case that those representations should apply to the executive level. That's my answer.
Thanks, Megan. Cheryl, in your view, from a constitutional view, what is the effect of the wording that the voice may make representations to both the Parliament and the executive government? But what obligations is that wording likely to impose?
Well, I don't think it attracts any obligations, but what it does is put in place a process. So there are two important aspects of those words you just read out, Luke. One is the word representations. I don't know who chose that word, but it's a very effective word in that particular context. It gets absolutely the meaning of a solemn representative expression of view going from one group to the Parliament and Government of Australia. In that sense, in a legal sense, it's a one-way street, although you would hope that politically it would attract a positive response. But the other relevant point to note about those words you read out, Luke, is that it's a discretion. The voice may make representations, and clearly that's sensible. It's not going to be able to make representations on everything relating to Aboriginal and Torres Strait Islander peoples. It will need to prioritise, and that section recognises its right and its responsibility to prioritise.
Kenneth, again, there's been a lot of public comment about the prospect that we are going to see a wave of executive decisions being reviewed in our courts, on the assertion that the executive has failed to properly consider a representation of the voice. Is that a realistic prospect?
I think it is not. I think it is a mirage which is seen as an amorphous fear. We need to begin, particularly as lawyers, we need to begin from the observation that judicial review of executive action is an ordinary, unremarkable function of the courts, which happens every day. But then, having observed that judicial review is an ordinary and unremarkable function of the courts, we have to recognise that you can get judicial review if and only if you have an arguable case brought by a plaintiff who has sufficient standing. And simply saying that a decision maker did not properly consider a representation by the voice will get you nowhere. It will not give anyone a case for review. And who would be the plaintiff that would have standing to complain if that plaintiff wanted to say that a representation made by the voice had not been, should have been, but had not been taken into account at all by a decision maker? But there's a still more fundamental point. And the more fundamental point is that 129.3 gives Parliament the power to make laws about whether, when, and how decision makers or particular kinds of decision makers should take account of a representation by the voice. So if, contrary to my view, judicial review of executive action were to emerge as some form of problem, and that's something I don't think will happen, Parliament can, and I expect would, deal with the issue by enacting a law or laws under 129.3. So the prospect of a wave of executive decisions being reviewed is, as I say, in my view, a mirage. I do not agree that it will happen.
Greg, did you have anything you wish to add to any of the comments in relation to this power to make representations to Parliament and the Executive?
Well, it's unlikely that the voice itself would have standing to challenge that, because it's not exercising a right. I mean, it will have made its representation. Its function then is over. And it's hard to imagine, as Kenneth was suggesting, who a plaintiff would be who would have that special interest. And they would have to be able to point to a right which was being infringed. So there'd have to be a matter which the court would have jurisdiction over. So and then you consider, well, who's likely to have the resources to be running this wave of litigation? And certainly not the least resourced peoples of our nation. So there are many reasons why there won't be a wave of litigation.
Megan, if I can direct the next question to you, and it's again, it's a question that has regularly been raised and is being given a lot of publicity in the ongoing debate, and that is that the questions are being asked of how many people will sit on the voice and how will members of the voice be elected. And where can I find the proposed legislation governing this? What is it that is the answer to those questions?
Yeah, thanks, Luke. And can I just add that I think that point in the last question is really important, that there is no obligation on the state, on the executive or Parliament, to respond to the representations made by First Nations peoples. I think that's a really critical piece in the discussion in the national debate. Some say that that's too weak. Some say it's too strong. We say it meets the temperament of the Australian legal and political system. So in relation to the detail, so I mean, the issue here is that constitutions are particular documents that don't involve huge amounts of detail. being included in the text. We say constitutions are for constitutional principle, and the Parliament is for legislation, is for the meat on the bones, is for the detail. Luke, there are many constitutional referendums and changes that occur all over the world every year. And there are always, this issue arises all the time about how much detail needs to go up front and how much detail follows the referendum. It's a complex decision that is made as to how much detail is deferred. So there is detail, and I'll get to it in a moment. But the question we're asking Australians to answer, or at least support, the fundamental principle we're asking Australians to support is recognition of First Nations peoples and the creation of an entity that will allow First Nations peoples to venture an opinion on laws and policies that are made about their communities. So we're asking Australians to vote on that principle. And if they say yes to that, then the Parliament does its job, as it does in the conventional way that our liberal democracy functions, of setting up that voice via a bill that everyone can have input into, that will finally become law, that puts the meat on the bones of what the provision has set out. And so it's not unlike, and I use this example a lot, of the way in which many different things were recognised as principle in the Australian Constitution when it came into force in 1901, such as the High Court. It's recognised as a body at that point, but the detail of it and the meat of the bones didn't occur for several years. And that's the job of Parliament. And so, you know, this is not like any ordinary vote. It is a vote on a constitution. And we say that there are risks with setting up a fully fledged body and asking Australians to vote on that. Not the least the political consequences of having a model in 2023 that's not fit for 2052. And that is why, that is another reason why we think it's important that that detail is worked out after the referendum. Apart from the fact that the Constitution is for principle and the Parliament is for detail, following the referendum, it follows, when we think about public institutions in our political and legal system, they require the trust of people for those institutions to retain legitimacy, which is how institutions function and thrive. And so post-referendum, there will be a process that enables First Nations communities to give input into what the voice might look like. And those views enter the Parliament through a bill in which the parliamentary processes and politicians and Australians can give input in, and other First Nations peoples can give input in, as they did with legislation, Luke, like the ATSIC legislation, keeping in mind that ATSIC and the Native Title Act are two of the longest running debates for bills in the history of the Australian Parliament. So this bill will be extremely scrutinised, but that will be the process to follow. So on the questions about how many members of the Voice will be elected, where can I find the proposed legislation? That proposed legislation doesn't exist because of what I just said. But there's been a lot of work done over the past 7 years that gives Australians some indication of what the Voice will look like. And that has been put into a document that was developed by the Referendum Working Group. And that contains a number of details about what the Voice will look like. So there's important principles in relation to the Voice, such as the members will not be appointed by government. They will be elected by local communities. And one of the most important things for me, because my PhD is on how constitutions can help Aboriginal women to flourish, one of the detailed principles is that it must have equal men and women. So there is detail out there, and it's important for Australians to go to places like the uluru statement.org, where we set out the detail principles for Australians to see that will help them make an informed choice at the ballot box.
Thank you, Megan. I'll come back to you in relation to the that process that will evolve if the referendum question is successful, because I think that's important as well. But can I just ask if any of the other panelists would like to make a comment in relation to this suggestion that there is an absence of detail that the Australian community needs to know?
Can I say this, Luke? Once you decide that constitutions are where principles are put, not machinery, it is inevitably quite wrong and would be entirely misleading now to say, oh, I can tell you what Parliament will do next year or the year after. That's for Parliament to decide. And so the suggestion of more detail, again, a mirage.
Can I just put a slightly different spin on that too, Luke? And this is really a thought that was put in my head by a student. I was giving a talk on The Voice, and she asked me a question, and it made me think like this. The proposed section 129 does have detail in it. It has all the details that we actually want to protect from ready amendment. So subsection 2 tells you what the Voice will do, who it will do it with, what it will do it about. Those are the things that we want to protect. How many members it will have, how they'll be chosen, exactly how they'll interact with the government and Parliament. Those are the things we don't want to protect in the Constitution, that we know will need to change over time, and those are left to the Parliament. And frankly, the discussion about we should have had the legislation right from the outset. Yeah, there was a lot of serious discussion about this amendment when it went through Parliament. In the end, it emerged in more or less the same form that it went in. But there were all sorts of proposals to change it. And if any of those changes had actually eventuated, whatever draft legislation was around would have been totally inappropriate. So the order in which you do things, clearly, you make up your mind what you want to protect in the Constitution, you pass the proposed amendment through the Parliament, you see what happens at referendum, and then you draft the legislation, the first lot of legislation.
Luke, agreeing with all of that, the fact that there are guiding principles really points us to the fact that at base there is no real difference between the informed yes and no cases to the extent that they are informed, and there are a lot that aren't. But those that are informed really are in agreement that whatever the Parliament looks at after the referendum, it'll be looking at a body which has local and regional representation and will be providing information from local and regional people about their issues up to the Parliament. And so in that sense, there's a surprising degree of unanimity between the yes and the no campaigns on the actual detail of what the Voice might look like.
Or that, I mean, the absence of the detail and the adherence to just the Constitution principles is in fact why it's such an orthodox proposal, of course. And Megan, you touched on that issue of the subsequent legislative debate that is likely to occur, and that the elected representatives of the Australian people will have their say, and that the Australians, all of us, can have our say in through that mechanism. How long do you expect that post-referendum process to take? And it's you referred to one of the earlier pieces of legislation and the length of time there. This process will involve significant discussion and consultation.
Yeah. I mean, I assume so, but I mean, I think Ken's made the point well. It's really up to Parliament and politicians how how long that will take, not me. I think the consultation period with our people doesn't have to be lengthy, because we live in the kind of country, and certainly our dialogues have shown that you can get around and consult people in a really deep and meaningful way if you want to. And that's an important point. But as for how long it's going to take, I can't speak for the Labor government as to what that time frame looks like. I mean, presumably, I don't know if anyone else wants to jump in. Presumably, they would want something done before the next election, but I'm not, you know, I'm not a politician, so I don't know what but certainly we would say it's urgent. You know, we're not seeing any substantive change in any of the gaps and disadvantage. And so we would say, you know, it was important for this work to be done quickly. But politician, right?
I've been assuming it's a job for 2024.
You would certainly hope that it has momentum.
Yeah.
Certainly the attorney has indicated that he is likely to want to get it into Parliament relatively quickly, but of course he's only part of the task.
Thank you. If we can move to another of the questions which has been submitted for your consideration, and that is, what are the potential negative impacts that this could have for Australia legally and socially? Kenneth, if I could direct that to you, is the proposed constitutional amendment legally risky, and will it result in a lawyer's picnic that has been described? You touched on the judicial review question. Is there other opportunities that may see this exploited by the profession?
I see no legal risk, Luke, and in particular, though this may disappoint some in the audience, I do not accept that there will be any lawyers' picnic if the referendum is passed. I say that for a couple of reasons. As several of the speakers have already mentioned, the word representations is very carefully and deliberately chosen. The voice has a power to speak. That's all. Parliament or the executive will decide what to do in response. The voice has no power of veto. The proposed amendment does not change in any way any power of the Parliament or the executive. It does not impose any obligation to consult. The voice has a power to speak. That's all. And I think it very telling that those who raise this issue seldom, if ever, go beyond saying that we should be afraid of what the High Court would do, but never go beyond to tell us what they think it is that the court could do. And the exceptions to those, that general criticism, are those who deliberately ignore the text of the proposed section 129, offer different words and say, well, based on those different words, then of course the court might well say X, Y, or Z. Well, that's not what the proposal is. So, legal risk? No. Lawyers' picnic? No.
Thank you, Kenneth. Did any of the other panellists wish to comment on that particular point about the amendment being a legal risk at all?
I think there are very good. I think there are good reasons based on the text and structure to go back to a familiar mantra to support what Ken just said. Megan, go.
Oh, no, I was just going to say, like, every terms of reference for the past 12 years has been about testing the suggested amendments for their legal and technical risk. I mean, as most people on this call know, that's what we've devoted our lives to for 12 years. The endless teleconferences, the endless workshops going back and forth about risk, that has driven, I mean, we are a country of very, very smart lawyers, you know, and we've spent, particularly lawyers across the political spectrum have spent the past 7 years trying to draft this in a way that it would minimise risk. And nobody, you know, and I think about my people going through these processes for the past 12 years, would never set out to design a reform that would rain negative consequences down upon their nation. That is not why they asked to have a voice to Parliament. My people are asking to have an enhanced role in the democratic decision-making of this country. And they wouldn't do that, given everything that has happened to them under the rule of law in this country. They would never pursue something that was legally and technically risky or something that would have a negative impact upon the social fabric of this nation. This nation. That's my response.
Luke, I've made the mistake of engaging in social media in this and elicited responses suggesting that I'm there to line my pockets. My view is exactly the same as Kenneth, that I think the chances of lawyers engaging in significant litigation is very minimal. As we said to the parliamentary inquiry, somebody might try it on. The High Court will deal with it in the way in which the High Court does deal with things, and one attempt is probably all that's likely to occur. The other thing is that when you drill down into this potential risk, it really gets down into what Kenneth was talking about earlier, which is the possibility of judicial review, administrative action by the executive, and that, of course, is capable of being controlled by the way in which the Parliament legislates.
To those points, doesn't it, this question of a lawyer's picnic, that even if we don't accept the premise that Kenneth started with, that it's highly unlikely, it can be controlled, and then there is precedent. So the risk of this picnic is minimal for those very practical reasons that govern our profession, as we all know, every day. Greg, if I can direct a question to you, particularly in relation to your experience in the native title sphere, that we have seen claims made that the voice will have the effect of converting private land to native title, or indeed have a broader effect on property ownership. Is there any legal basis for that concern at all?
None at all. I mean, as we've been saying repeatedly throughout this session, the voice's power is quite limited and quite focused. It's about making representations, saying things to the Parliament and to the executive. It will have absolutely no power to deal with land or impact anybody's title. I mean, our political system has been dealing with native title and land rights for the last 40 plus years. We've been dealing with it in a way which is highly controlled by law. It was the subject of a determination by the High Court in the Mabo decision, followed by the Native Title Act, and determinations have been made, and none of those determinations have ever adversely impacted upon the private property interests which were granted by the Crown to Australians, and there's no reason to expect that the voice or anything coming out of the Uluru Statement will have any impact of that kind.
That fear that is inherent in that question, it was similarly expressed in the immediate aftermath of Mabo as well, wasn't it? There was this idea that people were going to lose their backyards.
Yes.
Just hasn't happened.
We've had that post the Mabo decision, post the apology to the stolen generations. It seems to be a theme which certain elements of the public seem to want to wave around as a threat. First Nations people are not asking for anything like that in the most wild suggestions that have ever been made, and it's certainly something which the government and the parliament have control over in any event. I mean, the Native Title Act made it quite clear what impact native title would have on any private property interest, and it's none.
And can I say that last? Sorry, Cheryl.
I was going to say it's also maybe relevant, Luke, that the legislative power of the Parliament in subsection 3 is subject to this Constitution, which therefore means subject to the property protections in the Constitution. Little words that shouldn't be overlooked.
Yes, well, that's right. The power to provide just terms. If the government, I mean, the government does from time to time take people's land for public purposes, and it compensates them. It is obliged to provide them with appropriate notice and compensate them in accordance with international standards of confiscation of property. I mean, it's not impossible for government to do that. It's not something which is being given to First Nations peoples or the voice.
Thank you. Megan, if I can direct this question to you, and two parts to it. Is the voice going to lead to treaty? And conversely, will enshrining the voice in the Constitution cede First Nations sovereignty?
So in relation to treaty, I'd make my comment in the same way I would to the claims that it will lead to reparations. And Cheryl would know this, but the record at the end of every dialogue, people would sign off on what was known as a record of meeting. So although today, when we go out and talk to Aussies face-to-face, the trust that they have in their political institutions is at an all-time low, which is partly why they're saying, why would you trust politicians in this voice to Parliament? But the trust our people have in the political and legal system is worse. And so the only way to get them to participate in this constitutional process was to say that we would faithfully record everything they said. That was the record of meeting. The records of meetings are butcher's paper of people's thoughts in these meetings, word for word, to garner their trust. So we captured radical ideas right through to really benign ideas. Those records of meetings have been on, in the public domain for 7 years for people to read. But they've been, Sky News and others have said that they're a Trojan horse because there's all these radical ideas in there, including reparations. But what those ROMs are is the ideas of the men and women who participated in this process that were faithfully recorded in those butcher's papers so that they would participate. The really important thing, an answer to your question about treaty, is nothing happens in Australia at any jurisdiction without political agreement. Just because an old man in Broome said he wanted reparations on a piece of butcher's paper doesn't mean it's inevitable that it will happen. The voice to Parliament and the provision that we've read out today doesn't force or render inevitable anything anybody said in conference room butcher's papers. We are a nation in which things happen because of political agreement. We are having a referendum because of political agreement. And that's the important thing to know about treaty, reparation, or anything that was written in anything in relation to the Uluru Statement is these are aspirations of many, many different people. But aspirations aren't inevitable. Nothing is inevitable. And our people know nothing is inevitable. Everything that we have said in this process must be the subject of the political agreement of whether it's the Australian Parliament or state and territory parliaments. Now, treaty is underway in states and territories all across this country. Victoria is the most advanced. You have a process in South Australia, a process in Queensland, a process in the Northern Territory, one that's about to commence in New South Wales, I believe one that is commencing in Tasmania, and I think a commitment to one in WA, but I could be wrong, but I don't think I am. Well, Greg can answer that. But so that's already underway at that state and territory level. There is no political agreement to a treaty at a Commonwealth level. So that's, I think, the answer. Will it lead to treaty? I don't know. I think treaty advocates have been advocating for treaties since the 60s. Yeah, it's been an aspiration for people since that time, and it's happening at a state and territory level, probably because there's political agreement. So when the treaty legislation went through in Queensland, it had the support of the LNP. So my answer is I don't know. It depends on what happens at a particular time in a particular space. For example, South Australia had a treaty process. There was a change of government and the treaty process fell over. Then the Labor government got back in and the treaty process is starting again. So no one can really predict that, but certainly our people have always aspired to a document that brings together First Nations peoples and the Australian state. That really is also at the heart of the Uluru Statement and this referendum. In relation to the ceding of sovereignty, the answer is no. I think the easiest way of answering that, at least to First Nations people, is that no one can cede your sovereignty except you. No one can cede your sovereignty except the First Nation. And look, a lot of those conversations were had in different countries in 1788, because that's what treaties were at that point, the bringing together of two sovereignties or competing sovereignties. It's 2023, and so the notion of sovereignty has radically shifted in all different sectors, including the impact of international law upon Australian sovereignty. So, but the most simplest answer is no. I've never ever heard of an Aboriginal person who's ceded their sovereignty.
Clearly, sovereignty is not being ceded by any change to the Constitution, which is by its essence a document of the colonising body, and the referendum vote will be by the whole of the Australian population, not by First Nations peoples per se agreeing to anything in particular.
Cheryl, if I can direct the next question to you, is it likely that any current legislation would need to be amended to reflect a yes outcome of the referendum? The question was specifically put in relation to the Family Law Act, but if we could look at the question generally, does a yes outcome require amendment to existing provisions?
Look, everything that we've said on this webinar today, Luke, sort of points to no being the answer to that, in the sense that if the voice is established, its authority, its discretion is to make representations on matters relating to Aboriginal and Torres Strait Islander peoples, and those representations won't do anything unless the government and Parliament picks it up and decides to run with it. So to take the example of the Family Law Act that the questioner originally raised, it may well be down the track that the voice would make a representation on aspect of family law as they apply to the First Peoples or First Peoples families. But then that would be a matter for the Australian political process to think what to do about that representation. The only way in which that question actually made me pause a little bit is this. There are plenty of acts on the Commonwealth Statute Book, which creates executive discretions to deal with the Aboriginal people in one way or another. And it may be that once the Voice is up and running, the government might think, well, should we legislate to make the Voice a relevant consideration in relation to, say, decision-making under the Aboriginal heritage legislation, just to cover our bases in that way. So, you know, it may be down the track that government will do some sort of tidying up of that kind, but it's certainly not legislative change that would be precipitated by the establishment of the Voice under this amendment.
Cheryl, that really emphasises us in the point that Kenneth made earlier, the simplicity of the question and the concept that's being posed. It's all of that detail, all of the need to take on board any representation made will be dealt with appropriately by our elected representatives. This concept itself is simple, and it needs to be looked at in that simple way. And that's really the emphasis here.
And look, it will be looked at over time as well, Luke. I mean, Megan talked about, the next step being the consultation and the enactment of legislation, and that's clearly right. But then the legislation itself will take a period to settle down. The Voice will take a period to get its act together, and the government and parliament will need to work out how to operate as effectively as possible in relation to the Voice. So some of these questions that we've been discussing here today, they're not urgent, but they may come up with experience a little bit further down the track as this new institution begins to work.
Consistent with how the government has for the last 120 plus years dealt with and given effect to our constitution already. You know, we've referred to the High Court and its structure. Well, originally set up, it didn't have 7 justices, but as that process and as our community's needs changed and were assessed, appropriate machinery was put in place. And it's for that very reason, I think Megan made the point earlier, that we can't now set the detail for something in 2052. There needs to be that capacity, and to allow that capacity, we have to have this simplicity. We're coming to close to the end of our time. Can I just, and I'll go around each of the panellists, and I might allow you the final say, but can I ask you for your final thoughts and reflections, and if you could sum up, or in a few sentences, what Australians, and in particular the legal profession, should remember ahead of 14 October? What is it that you would say? And Greg, I might start with you.
Yes, thanks, Luke. My suggestion is that it's the amendment of the Constitution will put in place a procedure which will enhance the role of the Parliament and the Executive in the Parliament in enacting laws and the Executive in implementing policy and doing it in a way which is likely to be more effective. And the second thing is that it will not take away anything from the 97% of the population who are non-Indigenous.
Cheryl, if I could get your final thoughts and comments.
Yeah, well, look, a referendum is a very important moment in Australian democracy, and in a way, this referendum is particularly important. I think of it a little bit as First Peoples are clearly part of our national identity. This is about making them part of our constitutional identity in a very straightforward, streamlined way that fits our system of government extraordinarily well. But I think lawyers do have a special role to play in this. Lawyers understand text. lawyers understand how legal text is likely to be interpreted. We have responsibilities, and I think it's great that the Law Council's run this webinar at this moment to get lawyers thinking about how they can enhance the debate from now on.
It really is, isn't it, Cheryl, on that point, that the profession is uniquely qualified to be able to assist the Australian community to understand this issue. And as a profession, we have an obligation. We don't have, we're not advocating that people must vote, one way. It's a need to make an informed decision, and one that is properly informed and aware of what is being considered here.
Yeah.
Kenneth, any final comments and advice that you'd proffer to the profession?
3 sentences, Luke. The Uluru Statement asked us to recognise Aboriginal and Torres Strait Islander peoples as the first peoples of Australia by providing in our Constitution that they may speak to Parliament and the Executive. That's all that this amendment does. By recognising our First Peoples in our Constitution in this way, we lose nothing, but we gain so much for the whole nation.
And Megan, if I can allow you the last word.
Well, everybody knows I'm terrible at last words because they can go on for hours. I don't know. There's so much to say to the profession because it plays a really important role in, Australians look to lawyers at times like these for information, civics education, legal education about the reform. It's a very unique time. Referendums don't come very often. I suppose as a lawyer, I think back to not being unlike a lot of Aboriginal lawyers, being, quite angry after receiving things like your grandfather's files that had all of the mission and reserve, that kind of protection era documents that showed the way in which our rule of law very actively excluded our people for a very long time from the Australian society, not just through the Constitution, but through laws and policies that subjugated us and excluded us through compulsory racial segregation. And then I decided, I decided to become an academic and start looking at law reform. And I've spent 20 years or a bit at UNSW, and the first person I worked with was the now departed Professor Garth Nettheim. And he was I spent a long time talking to him about the way he was of course Jewish. I'm Aboriginal. We would talk about the ways in which law has sanctioned terrible, terrible things. But he always used to say to me, Megan, the law can oppress, but the law can redeem. And so I've learned a lot from him over the years about the many different ways that liberal democracies make changes to their structures to recognise and include Indigenous peoples within the framework of their democratic states. And when we started this work, so many of our mob were distrustful and didn't want to participate. But we said to them, look, law reform is about imagination. You have to imagine that the world can be a better place. And we have to ask you to suspend your belief that the nation can't change. And we have to suspend, your belief that things can't get better. And one of the most persuasive things for them was that the Australian drafters of the Constitution set the Constitution up to change. And not like some government constitutions where it's 3/4 of a parliament, but by the Australian people changing it. And that's why they issued the Uluru Statement. this one-page law reform proposal to the Australian people. And I remember listening to the elders at the time say, let's issue it to them as a hand of friendship, a olive branch, because most of them had grown up in 67. And of course, we're all sitting to the side going, really, only 8 out of 44? Are you serious? But they really honestly believed that this statement of love, which is what the Uluru Statement from the heart means, was an important representation to Australians about what repair might look like in this country for our people. It is meant to bring Australians together. That is what an expression of love is. It is meant to be a sign of peace. It is meant to be about belonging, not just about us, though, for Australians who grow up on an Aboriginal footprint. It is supported by more than 80% of our people. We know that not just through the polls, but because we've spent 7 years travelling around to our communities and talking about it. We worked really hard to meet that threshold of a legally and technically safe amendment, which I think is being well prosecuted by my friends on the panel today. It's a safe and modest proposal. It can work. And I think I can't see any, of course, negative consequences of this for the nation. I can only see positive consequences, in that it will bring unity and a greater sense of belonging to the country. And for the first time since 1788, we have spoken to formally the original grievance that our people carry in their hearts and in their health. It is such a modest proposal for such overwhelming outcomes, positive outcomes that this will have for the Australian people.
Can I just, on behalf of all attendees, thank the four of you, Professor Dr. Megan Davis, the Honourable Kenneth Hayne AC KC, Professor Cheryl Saunders AO, and Mr Greg McIntyre SC, for your participation and contribution today. We are indebted to you all for your time and insights. As we, the Australian community, is now aware, an amendment to the Australian Constitution is a momentous event for the country. The community, appropriately, takes seriously the task of voting to amend Australia's supreme legal document. I hope that this discussion has assisted all attendees understanding about the proposed amendment, and will allow each of you to explain to non-legally qualified Australians why the referendum is being held and the legal implications of the proposed change. As we've said, we as a profession are uniquely qualified to fulfil this obligation. Finally, I encourage all of you to consider the Law Council's guide for the legal profession, as well as the various fact sheets, which are all available online. Please utilise those resources and share them widely in your own communities in the coming weeks. They will assist in ensuring that all interested Australians know what the proposed amendment entails. We will circulate the link to you all following this webinar. Thank you all for attending, and good luck.
Thanks, Luke.
Thank you.